we're recording so that we can share this. We're going to share the recording and the materials later.
Great. Can everyone see the PowerPoint and hear me?
Yes.
Okay, great. So nice to see everyone. My name is Abby Codiari. I know I've met some of you before. I'm a senior staff attorney at Bay Area Legal Aid, and I'm co-presenting today with Monique Doryland, who's also a senior staff attorney at Bay Area Legal Aid. We've done this training for this group before, but I think it's always good to have a refresher if you've seen it before, and also helpful for new staff. And laws change, things change, so it's always helpful to go through it again. We just talked about it a little bit, but I think just because of how large the group is and how long the training could potentially go, it might be good to save questions. There will be a few times where Monique and I switch off and we can ask for questions at those points, or save till the end. Of course, if something super urgent comes up, or it feels important to ask the question in the moment, you can interrupt me. I don't mind being interrupted, or put it in the chat, and I think Jamie and Shelby will be watching the chat. So let's get right into it. We're going to talk today about tenants' rights and fair housing. The agenda today, and I know we have 2 hours together. I think if we end early and do questions, that would be great, but this is the kind of massive agenda we have today. So we're going to talk about tenants' rights. Under tenants' rights, the umbrella of tenants' rights are rental qualifications when someone is applying for a property. I want to talk about understanding leases and some common clauses or parts that would be included in a lease. Habitability, which is concerns about the premises, like if there's mold, that's something we have come up a lot, bed bugs, other kinds of bugs, issues with the unit that the person's going to be living in. We're going to talk a little bit too about criminal history information and how that can be used in the application process for a unit. And then just some very general best practices. After we talk about those basic tenants' rights, we will get more deep into the fair housing protections. Fair housing is the body of law essentially that protects tenants from being discriminated against, both in the unit that they already live in and also in applications for new housing. So it protects potential tenants as well. We'll talk about federal and state protections. They're slightly different. And then we'll talk about reasonable accommodations for disabilities. We'll talk about, this says new, it's new-ish at this point, but source of income discrimination, what that means and what it looks like and how to spot it. And then protection for immigrant tenants as well. So let's dive right in. I'm also going to talk about, a little bit about who we are, what Bay Area Legal Aid is. We are the largest Bay Area provider of free civil legal services. We practice in all of these areas. I won't read everything just because it's a lot. And what we're focusing on today is the top row here, which says housing preservation and homelessness prevention. The main bulk of our practice here is eviction defense. So for folks that are housed but have received an eviction notice or have been served with the eviction lawsuit, also called an unlawful detainer. We represent on those cases, but the other work we do is also this fair housing work that I keep mentioning. Basically fair housing, like a term for discrimination. We work on housing discrimination cases. We also work on all of the issues that are unique to subsidized housing. So most of our clients are in some sort of subsidized housing, whether they have a Section 8 voucher or they live in public housing or something called project-based Section 8. We like to work specifically with those tenant populations just because if you lose one of these housing subsidies, it can be really hard, if not impossible, to get it back. And a lot of folks on fixed incomes or receiving Social Security or other assistance like that really rely on their housing subsidy in order to remain housed and stay healthy. We also provide wraparound services, which is something I really love. The position I'm in, I specifically work on a medical legal partnership where we work with county providers such as yourself to send over legal issues that may or may not be affecting the patient's health. And as part of that, we work on housing issues, certainly, but we are also able to do wraparound services. So if we spot, someone's referred for an eviction, but we also see that they maybe are not a citizen, but might have a pathway to citizenship, we might help with open an immigration case. We might help with domestic violence, help them get the correct amount of general assistance or whatever public benefit they might be on. So I really like that about Bay Area Legal Aid, is that we can get a referral for one issue, but provide wraparound services in other areas as well. Our client eligibility, they must live in, actually, this isn't all the way true. So most of our clients do live in Alameda, Contra Costa, Napa, Marin, Santa Clara, San Francisco, or San Mateo counties. They don't have to, though. Another way that a client might be eligible is if their legal issue has occurred in one of these counties. So maybe they've already moved to San Joaquin County, but just received notice that they had an eviction filed in Contra Costa, like someone thinks they're still living there or something like that. So we help people as long as the legal issue is within one of our service counties. We also, because we get money from the federal government, we are supposed to work with folks who are US citizens or certain family members of a US citizen or someone with a pending application for permanent residency. We can also make exceptions to this for an immigrant who is a victim of domestic violence, sexual assault, human trafficking, or other violent crime. There are other exceptions to this as well, but I like to be upfront about that. Sometimes when we get referrals for folks who might not be eligible because of citizenship stuff, we can make referrals to other organizations in the county who might be able to more quickly assist them. We also have income requirements. So the gross income of our clients generally has to be under 200% of the federal poverty level, except for our health work. Our Health Consumer Center gets different funding to work on mostly like Medi-Cal and healthcare access issues, and they can help people who are above 200% of the federal poverty line. But even if we see someone who is like slightly above, we have workarounds, ways to spend them down and get them under that 200% so that we can open cases. So I want to be totally upfront about all these eligibility criteria, but also ways we try to get around them when we can. The ways to access our services, our centralized intake unit is based out of Oakland, but you call this number no matter what county you're in to access legal advice and other Bay Area legal aid services. So if you have a person you're working with who needs help, they would call this 800 number right there in order to access our services. And it's on our website. The hours are there as well. I always recommend calling right at 9:30 when they open on the day that they're open, because sometimes the wait can get really long. There's an option. The person calling doesn't have to wait on the phone. They can opt to get a call back, but it just can take a long time and get complicated. So I always recommend, if you want to call, make sure you're calling right at 9:30 a.m. With that, I will jump right into tenants' rights. Talking first about rental qualifications. So landlords can ask for many different things when someone applies for housing. Many of the things might seem invasive, or maybe the relevance could be questionable, but many things are perfectly legal for a landlord to ask about. They can generally ask for names and contact information of current or past landlords, your employer, and they could ask for other references, maybe personal references as well. They might require applicants to provide a screening fee to cover the costs of obtaining a credit report. There's a maximum amount that a prospective landlord can charge for this screening fee. I don't know what it is today. I think it might be $50, no more than 50, but I'd have to double check on that. The landlord can also definitely ask about financial qualifications of the potential tenant. They might ask for proof of income, and maybe, you know, like some pay stubs or something like that, just to show that the tenant will be able to afford the rent. Looks like someone might have come unmuted. There we go. Okay. So landlords in the past have been able to ask quite a lot about criminal history, but effective January 1st, 2020, new California regulations interpreting anti-discrimination laws prohibited landlords from considering certain types of criminal history. So landlords in California now cannot consider an arrest that did not lead to a conviction. So oftentimes someone will get arrested. The district attorney or the prosecutor will consider pressing charges and then decides not to file anything. So that would be something that a landlord cannot consider. They also they can't consider participation in a pretrial or post-trial diversion program, any record of a conviction that's been sealed, or anything that came from the juvenile justice system. So landlords cannot consider any of those things. They also, landlords are prohibited from having, quote, blanket bans, saying like, do not apply if you have a criminal history. They would have to consider the circumstances and like the length of time, how long ago it was, how relevant it is to their tenancy and ability to pay rent on time and be a good tenant, stuff like that. Certain cities, like Richmond, for instance, have fair chance ordinances that even further this protection for potential tenants and what landlords can and cannot consider when looking at criminal history. So housing provider also cannot access criminal or civil records older than 7 years. So if a landlord is saying, you know, you've been denied because of this arrest and you realize this arrest was from 10 years ago, that is unlawful and the landlord should not have considered that. Again, they can't use or ask for information about arrests that did not lead to convictions. No blanket, no felon policies or other exclusionary policies like that. They can't even ask about juvenile adjudications because they're not allowed to consider it, nothing that's been expunged. They can't try to like interview and ask questions that might lead to information about an expunged criminal record. Also can't deny someone whose qualifications are a function of disability, and we will get a little more into what that looks like in a bit. They also can't deny someone whose qualifications are related to a history of being a victim of domestic violence. And we're going to talk in depth about VAWA later, the Violence Against Women Act, and how that protects tenants who have been a victim of domestic violence. Another duty of a landlord, the landlord has the duty to provide a habitable unit. So what does that mean? That means that a unit that is habitable is fit for occupation by human beings, and it substantially complies with the state and local building and health codes that materially affect tenants' health and safety. That's what I get for just reading off the slide, is I don't read the words right. But so what that means, I mean, what that like in practice really looks like is, you know, there are in the state code and, you know, the state laws, it says that, you know, the landlord has to provide a working heater or needs to provide a unit free of mold with working locks and other, you know, health and safety type things. So before the landlord rents out the unit, they need to make sure that it's fit to live in and it's habitable. During the tenancy, they need to maintain those things. So they need to make sure that if the tenant tells them that there is a repair that needs to be made or a habitability concern, that they fix it within a reasonable amount of time. If the tenant notices something in the unit that is a problem or a potential habitability issue, it's on the tenant to notify the landlord right away. That's because typically if the tenant doesn't tell the landlord, they couldn't have known about it and then they can't fix it. The duty to fix it begins once they know about it. What if a tenant substantially causes the unlivable condition? In that instance, the tenant may be responsible for the cost of repairs. So it's a landlord's responsibility to fix things when it's not the tenant's fault. I've had cases, where like a kid maybe accidentally broke a window or something like that. And in those situations, often it's the tenant's responsibility to pay for that, that issue to be fixed. There are some different remedies for the tenant if the landlord does not conduct the repairs. They can contact the city code enforcement. This can be kind of iffy. It can often be really hard to get the city code enforcement to take action and come out to the unit. And then sometimes if they do and they come out and they see that the unit is not habitable, they'll give the landlord a warning typically. And if the landlord still doesn't fix it, then they might do what's called red tag the unit, meaning they have deemed it not safe for someone to live in. And then the tenant will have to move, which oftentimes is kind of a worse situation if someone was relying on that housing. Obviously, you want it to be habitable, but that can cause another issue if the person needs to then move. Repair and deduct remedy is when a tenant repairs something in the unit out of pocket and then deducts that amount from their rent. We do not ever recommend this because what typically will happen is the landlord will then give the tenant a 3-day notice to pay or quit for that amount. And if the landlord decides to pursue this in court, they will sue for non-payment. The tenant will have to go to court and show, receipts and everything that they repaired and deducted. And it's just kind of complicated. And we never know how tenant friendly a judge or jury will be. It's just kind of a big risk to do this. And that's why we never recommend it. The tenant could also withhold the rent, also not recommended for the same reason. And they can file a lawsuit against the landlord for habitability to try to get some of that rent back that they paid while the unit was not habitable. Or they could sue for constructive eviction. Constructive eviction essentially means like you weren't actually evicted by the court, but the premises became so uninhabitable that you had to leave. Like essentially you were evicted because you just could not live there anymore. So I have a quick hypothetical question. Tammy tenant has a rental agreement where she agrees to pay $1,000 in rent. A year into her tenancy, she has a roach infestation in her unit. She verbally told her landlord. Her landlord immediately contacted pest control. Pest control came and they eradicated the roaches. 6 months later, Tammy notices roaches and ants in her kitchen again. She does not tell her landlord and she withholds rent for the month. What best practices should Tammy have done? A, provided notice in writing. B, inform the landlord after habitability issues started again. C, take pictures. D, all of the above. So maybe the best way to do this is to put it in the chat what folks think. Oh, you guys already are on it. Yes, yes, yes. Perfect. You got it. You guys are great. So number 2, true or false? If Tammy's landlord files an eviction action, Tammy can assert habitability as a defense.
I'm just going to note that the way your slides are showing, the answers are showing.
Oh
You
no.
too.
Well, I still think you all are so smart. I'm sure you put it in before you saw the answers. I was just trying to minimize it so I could see the chat, but never mind. Okay. So yeah, I think you guys, I don't see the answers. Monique, are they getting it for the true or false?
Mostly, yes.
And what's the answer, guys? True, true, true. Yes. Okay, great. Everyone, that was awesome. Sorry about the technical issues. You would think 2 years into the pandemic, I would have this. But I'm going to pass it to Monique. Please, maybe we should pause for a second and see if there were any questions about what I just talked about in terms of tenants' rights. Oh, I see Monique was answering them. Awesome. Okay, I will pass it to Monique. We can also answer more questions at the end, but take it from here.
I see JC Santos raised their hand. What's the question?
I saw that there was another service provider that had said something about what about carpets? Actually, I saw the response here. So forget that I raised my hand. Thank you.
Okay, so I apologize in advance. I'm going to have to ask Abby to move to each slide. So I apologize. That's distracting. I'm going to focus in on fair housing laws. And one thing that's useful to remember is that parallel to housing laws are employment laws. When these laws were first passed, they often became amended over time, but they often also apply to your rights as an employee or your responsibilities as an employer, as the case may be. So sorry about that. We have the Fair Housing Act, which was passed, I believe, in 1965. Originally, it addressed issues of race. It was illegal to discriminate against somebody because of their color or race. But it has been amended, and specifically there's the Fair Housing Act as amended. That adds a lot of other areas of protection. And I wanted to mention before I got too farther along, there are some exceptions to these laws. If the landlord lives in the very same building and the building is less than, am I not loud enough?
I can hear you fine.
I'm going to try to make my computer louder.
I also had forgotten to enable auto transcript, live transcript, so
None.
that should work too.
Can people hear me now?
Yes.
Okay. So there are a couple of exceptions. If you live in a dormitory or something run by a private religious group, there are some exceptions, but generally all landlords are required to observe the laws that we're talking about here. So Section 504 of the Rehabilitation Act only applies to landlords who receive certain federal funds. So for example, public housing. There are extra protections for the landlords who receive 504 funding. But the Americans with Disabilities Act, the Fair Housing Amendments Act, and the Fair Housing Act apply to all landlords with these narrow exceptions. We also have in California, the Fair Employment and Housing Act, which has similar or sometimes even better discrimination protections for tenants. There's also Civil Code 51, the Unruh Civil Rights Act, which prevents certain types of discrimination, and that is also applicable to housing. And I think the next slide, if you see over on the left on the screen, federal law provides protections for people based on their race, their color, their religion, their sex, their family status, their national origin, and also disability, physical, mental, or both. California is more inclusive, has more protections. That's on the right. So it has all of those on the left, plus your marital status. You can't refuse to rent to somebody because they're married or because they're single. Also your ancestry, your sexual orientation, gender expression, and identity, your source of income. In other words, I can't say I don't want to rent to you because you have SSI. I don't want to rent to you because you're working and you have employment income. Also medical condition or genetic information. If I find out you have a certain disease or illness or something tied to your DNA, I can't refuse to rent to you. I can't refuse to rent to you because of your veteran status, because you are a veteran or because you're not a veteran, and also because of your primary language and immigration status. And everybody is in a protected class. Everybody is a something. Everybody is a race, a color, a gender, a sex, a national origin. So protected classes are not just applicable to people that traditionally were referred to as quote unquote minorities. Everybody is a protected class. So, you know, an example is a landlord who only puts up a sign that something is for rent in a language other than English, arguably is discriminating against English speakers. I think in reality, the majority of discrimination that you would see in real life is where somebody who is in a more dominant, powerful position is discriminating against people who have traditionally less power in the society. But I just wanted to make it clear that everybody is in a protected class of some type for employment and housing law. Next slide. we're now specifically talking about HUD, which is the United States Department of Housing and Urban Development. And this is, HUD is not saying per se that this is a type of discrimination as a protected class, but they are saying that anyone who's identified, or, and I think someone has their mute off. Thank you.
I think we got it.
Okay. If you are perceived as, or if you are lesbian, gay, bisexual, transgender, queer, and or you're questioning your identity, you are protected from housing discrimination. In that HUD equal access rule says that housing must be made available without regard to your actual or perceived sexual orientation, gender identity, or marital status. And this also expands the definition of what is a family in most of HUD's programs. And the point of this equal access rule is that people who are receiving or are trying to receive benefits from HUD subsidized housing, including homeless shelters, should be protected from any type of discrimination based on their gender identity or the perception or the reality that they are lesbian, gay, bisexual, transgender, queer, or questioning. And this applies also to providers that operate single-sex projects, so that if somebody's transgendered, they don't, they are required to be provided services based on the gender they present as. And you can report a failure to provide you with equal access to HUD, again, the United States Department of Housing and Urban Development. It has a website. This is a federal agency, so we're talking about this is true in all 50 states and United States territories. If there's questions in the chat, I just want to point out I'm not having an opportunity to look at them now, and we will try to get to those. And the next slide. So it's interesting, if you think of fair housing, it actually applies to people who are trying to get a mortgage, people who are trying to refinance their mortgage. And it also applies at the beginning of the process. What is a landlord allowed to say in an advertisement? Excuse me. You may notice that when somebody is telling you that they're willing to sell you a mortgage, they're advertising on the radio or on the internet, they may say fair housing provider. That means that they're aware of their obligations under fair housing law. Smaller landlords are not as aware of that. They're not allowed to say no children, no married couples. This applies in the process of trying to get leased up with a private provider or with the housing authority, somebody who has a voucher or is trying to get a voucher. Also in terms of the screening, the terms and conditions of a tenancy, and evictions or termination of tenancy. And next slide. I'm sorry if I'm going too quickly, but we want to make sure we get through everything and have enough time for questions. So you cannot intentionally choose to treat someone who's a protected class, in other words, anybody, differently than you would treat someone else because of their membership in the protected class. I don't want to rent to you because of your religion. Doesn't matter what your religion is or what my religion is, or if you're an atheist or I'm an atheist. I can't refuse to rent to you because of that. That is a protected class. It doesn't apply only to a religion you've never heard of before, or only to religions you have heard of, like being a Catholic. There's also in fair housing law the idea of disparate impact, that if a housing provider has an appearance of neutrality, they're not saying, I don't want to rent to anybody with Section 8, I don't want to rent to anybody who's married. But the way that they carry out their advertisement or their provision of housing, who they choose as a tenant, that is discriminatory on a protected class. Also, landlords are not allowed to engage in sexual harassment. There are specific statutes in California that make landlords liable for a civil action, where you can sue a landlord for money because they are creating a hostile environment. For example, they understand that the tenant's broke and the tenant owes rent, and they make it clear that the tenant can exchange sexual favors for rent. That's illegal. There's also vicarious liability. You are responsible for what your maintenance people do, for what your management team does. There's also a specific area of law, and Abby will talk a little bit more about this when she talks about VAWA, but people who are survivors of domestic violence have specific protections for discrimination under fair housing law. So I'm going to ask a question, and again, people can answer in the chat. Tom Tennant lives in a large apartment complex in Concord. He lives in his apartment with his 3 children. The landlord or the manager tells him children are not allowed to be outside playing in the common area at any time. Can the landlord institute this rule? What do people think is the answer? I'm not going to look at the chat because that reveals the answer.
We're getting a lot of B's.
I think that's very exciting because that means that people are very familiar with fair housing law, and we're thrilled to hear that. Yes, that is family status discrimination, and you can sue the landlord for that. They're not allowed to say that. They're not allowed to also say, parenthetically, which has nothing to do with the hypo, they're not allowed to say, oh, I'm worried your kids are going to get in trouble if I rent to you at a higher floor. I only rent to people with kids on the ground floor. That's also prohibited discrimination based on family status. And next slide. Here are the obvious intentional discrimination examples. I refuse to rent to you or to sell you a house or to make you a mortgage because of who you are. Also discouraging applications from people in a protected class. Coming up with different rental terms or rules based on who you are. Enforcing lease terms or house rules differently because of who you are. Segregating people through advertisement, steering, or physical separation. Steering is, oh, I'm only going to show people in this group of protected class. Third-party payments, that would be prohibited discrimination. There's a case in the Ninth Circuit. It kind of depends on the facts, but there's a strong case, Giebler, that came out several years ago where the landlord said, I don't want to rent to you because you said your mom is going to be the co-signer, and the landlord said no. But we can talk more about that in the questions. Also, if I choose to respond to you differently based on who you are, based on your request for repairs and maintenance. And again, sort of underlying this, just treating applications differently. Next slide. And here we are on the more hard to quantify disparate impact. So you don't want to rent to survivors of domestic violence because somebody was evicted because their abuser was violent, or a rule that a tenant has to come to the management office to do an annual recertification, or maybe the tenant has a physical or mental disability. A landlord needs to be more flexible about that. A lease term requiring that rent is paid on the first of the month. Suppose you have people living in the apartment complex who get their money from, say, SSI or SSDI, and the money doesn't show up in their bank account until the 5th of the month. You have to be flexible about that. You have to allow the rent to be paid when the tenant has the money in their bank account. You can't say it's due on the 1st for everybody. Also, if you had a partner who was acting in an abusive manner, and part of that was that they were spending your common money in such a way that you now have bad credit because of what they were doing in an abusive relationship, that would also be an example of disparate impact. And next slide. And again, Abby's going to talk in a minute more about the Violence Against Women Act, but specifically survivors of domestic violence are not a protected class under either state or federal housing law. But statistically, most people who experience domestic violence, not all, but most, are women. And as HUD says here in a fair housing enforcement memo, women are 5 to 8 times more likely than men to be victimized by an intimate partner. More than 70% of those people murdered by their intimate partners are women. So there is a connection between domestic violence and refusing to rent to somebody or discriminating against somebody because of their gender. So there is a connection that HUD recognizes and federal and state housing law recognizes between the fact that most victims of domestic violence are women, and that you can't refuse to rent to somebody because of their gender, or treating somebody differently because of their gender. And next slide. Policies that can violate fair housing laws. Obviously, this could be really broad, but evictions or terminations based on violence against a survivor. Policies that are also based on gender stereotypes. An owner evicts women with a history of domestic violence because they always go back to the men who abused them. Treating women differently because they have been victims of domestic violence. Example, the ex-boyfriend broke into her unit. She called the police. That person faces eviction because of what happened to the unit. But another tenant, a total stranger, broke into their unit, a burglar, and they don't face eviction. And also property damage that was caused by the abuser. And this is sort of a nice transition to the Violence Against Women Act, but do people want to ask some questions?
There's a question in the chat.
Okay,
It says, what about landlords who will not accept third-party payments in regard to rent? I would like to think the majority of subsidized housing programs pay directly to the landlord, and that it's likely the majority of landlords are aware of this fact.
that may be true for subsidized housing. It's complicated. It depends on what the facts are. But as I said, there's in the federal area that we live in, the Ninth Circuit, there's a case where a third-party payer in a private housing, the landlord's refusal to accept that was just considered to be an act of discrimination against that tenant. I'm not sure if that answers that question well enough. It's a complicated question. That's a really good question. I don't know. It would be very fact specific. If you are in fear of somebody who's going after you from something 5 years ago, well, you're actually in fear of that. And maybe that person is sending you text messages or sending you messages on Facebook threatening you or sending you messages through a third party. I'm going to let Abby talk about, HUD has rules about this. If the woman is the person committing domestic violence and is the voucher holder, it's complicated, but HUD has rules for how Section 8 is supposed to deal with this. And we can look up the specific rules and get back to you, but there is a way for the person who is a survivor of domestic violence to become the voucher holder and the abuser to be removed from the voucher. But I'll turn it over to Abby now.
Thank you. Darlene, did you have another question? I see your hand raised.
Yes, I have a question. Like far as like the victim of domestic violence and also just regular tenants, like say, how can you how do HUD weed out the, let's say, slumlords? Like say, for instance, you have a landlord that quick to take your money, quick to evict you and stuff like that. But when it comes down to, like, say, for instance, a client that receives Section 8 or that's in the project-based apartments, project-based voucher in an apartment complex. But the maintenance people are not doing their job, and service requests is going out as far as both ways. And they're not doing anything to fix the problem or the solution. But HUD, the landlord, will reach out to HUD housing or whoever the case may be, the higher ups, and send an email saying that the tenant's not doing this, tenant's not doing that. They have evidence of the tenant not paying rent, but the tenant is withholding the rent, not saying they're not paying it. they're withholding the rent due to the landlord being a slumlord. And then when the tenant sends emails, pictures, and all that out to housing, HUD and all that, sometimes it doesn't go in the favor of the tenant. It always goes in its favor of the slumlord. Then the slumlord turns around and does the same thing to another tenant.
Yeah, so I think we talked about it or I mentioned it, that when there's habitability problems, technically a tenant is like under California law, it says that they can withhold rent or repair and deduct, but we never ever recommend doing it just because it's really risky for tenants for exactly the reasons you were just kind of explaining, that they can withhold the money, but then the landlord will just kind of paint it as this is a tenant who's just not paying their rent. When really it's a landlord that's not complying with their duty. The tenant is trying to assert their rights by withholding rent. But it's just too risky because you don't know how a judge will see it or how a jury will see it. And especially if the person has a voucher or something like that that they really don't want to lose, it's very risky to withhold rent. So the big takeaway is we don't ever recommend that. But the rest of these cases are really fact specific, and the person, if they end up getting evicted or getting sued for non-payment by their landlord, then they would need to use the habitability issues as a defense in that lawsuit. That's kind of how you would use those facts to make that argument.
Okay, now once the habitability, you have all of that, but sometimes, it goes above and beyond depending on who's behind the desk of the HUD people as well.
Yeah, it's really fact specific, and it really depends on that's why I think it's too much of a risk, because you never know who the person is on the other side making the decisions. And it can vary a lot. You just don't know how it's going to shake out. Does that answer your question? I think you kind of explained like exactly the concerns with withholding rent.
Yeah, thank you. I appreciate that.
Yeah, thank you. Lucinda, I see your hand up too.
I have a question about the application process. We have an issue where we are submitting an application as a third party on the behalf of our clients, but what's happening is they're sending us the lead and sending a message to the client and myself as well, stating to go and tour the property. We've toured the property, we've submitted the application fee, but they have not processed yet, and they have not communicated with us yet. I've sent emails and I've called. What I would like to know is, do you ladies offer any advice? If this is a legal practice, can they do that without explanation as to what happened to the fees that we have submitted? Because no application has been granted. And
Yeah,
so
I think
other people are getting into those units, but they have not told us whether or not our client has
I think generally in situations like this, the best thing to do is to put everything in writing and ask for when you'll hear back, if they've been denied, and if they have been denied, ask for the reason in writing, because there's a chance it's for a discriminatory reason. And so you want to make sure to get in writing the reason for the denial. And if it's subsidized housing, sometimes, there will be like specific language they need to include in that denial and an appeal process for being denied. So you'll really, really want to get that in writing, and maybe it's just taking time to review applications, and that's fine. I'm not sure, depending on how much availability they have, what a reasonable amount of time might be. But I would make sure to put everything in writing, send it to them in, letters, keep copies for your own records or for the tenant's records, to try and figure out what's happening, again, in writing. Monique, I'm not sure if you have another idea to force them to respond, I guess. I think that would be the information I would give.
I'd want to know more about the facts. It's really hard to know whether something is held up because there's an inefficiency in a program or in a management office, or whether they are acting in a discriminatory manner. I think Abby's advice is to best start documenting everything. The more they get like emails or letters, even old-fashioned letters on paper, it's been 3 weeks since we first applied for Mr. Jones, and We've yet to receive a response. Please respond. It's tricky because you don't know right now if this is an act of discrimination or whether they're just inefficient.
I've actually done all of the things above that you guys have stated. I'm pretty well versed with fair housing. I've also been a property manager myself for HUD. So I do know some of the legalities behind it. My issue is just making sure that there is no discrimination, that my client is not being passed up. Because I think in 3 weeks, there should have been some sense of being aware whether or not he qualified. If he does qualify, that's fine. I would like them to state that. So that way we can know that he is at least in the queue for the next available apartment. So far, we don't know those things. And I followed all of the process that I'm supposed to follow to communicate with them in writing. I've gone in person, I've called. So I'm looking forward to the next step, because otherwise it's just holding someone's money hostage until you decide that you want to either approve them or deny them, all the while sending emails to the third party as well as the client stating that, have you gone and scheduled for this second unit, and then send me an email back stating that that unit is no longer available, which I think is unfair.
I mean, you can, without any assistance, you can go online and help this person do a fair housing discrimination complaint with either the California Commission on Civil Rights, which until about a week ago was called the California Department of Fair Employment and Housing, or with HUD. I don't know if that discrimination complaint done administratively will change anything, but it's an option at this point. If you can clarify before you go to those websites what type of discrimination you believe the person is experiencing, and if it's based on something that only California law covers, then you have to go to the website for the Commission on Civil Rights, which you could probably find pretty easily still on Google, just typing in California Department of Fair Employment and Housing, or DFEH. But
Thank
I'm
you.
gonna, I know there's more questions, but Abby, did you want to continue to answer questions, or did you want to?
Yeah, let's keep moving for now, and we can talk more. I'm sure we'll have some time at the end so we can answer more questions then. And then Monique, if you don't mind, if you see anything you can answer quickly in the chat, just go for it. So I'll start talking now about the Violence Against Women Act, or we call it VAWA. The Violence Against Women Act. Then before I get started, I just wanted to quickly say, so historically, the Violence Against Women Act was passed in 1994, and it has, by some, like prison abolition folks, has been rightfully criticized for some aspects of it, particularly its focus on policing and enforcement, and the way it goes about that. I'm going to talk here specifically. I'm not going to get into the broader VAWA. I'm going to talk very specifically about the protections it provides to survivors of domestic violence in the housing context. But I did just want to mention that, and you all can do more research or look into that at another time, but I wanted to mention it. So VAWA within housing is intended to encourage survivors of domestic violence who receive housing subsidies to report and seek help for the abuse committed against them without being afraid of eviction or of losing that subsidy. And again, when I say subsidy, I mean Section 8 voucher, public housing unit, etc. VAWA protects individuals who are applying for or living in federally subsidized housing from being discriminated against because of acts of domestic violence, sexual assault, stalking, dating violence, and dating violence committed against them. Even though it's called the Violence Against Women Act, it applies and protects both men and women and any gender of person, regardless of identity, sexual orientation, sex, anything. But it only protects folks, since it's a federal law, it protects folks that live in federal housing programs. And to just kind of get more into the nitty gritty here, this is exactly who it is meant to protect. Any under domestic violence, any felony or misdemeanor crimes of violence committed by a current or former spouse, intimate partner, person with whom the victim shares a child, or person who is or has cohabitated with the victim. It also protects against dating violence, violence committed by a person who is or was in a social relationship of intimate nature with the victim. Sexual assault, that's any non-consensual sexual act prohibited by law. Stalking, that's any conduct directed towards a specific person that would cause a reasonable person to fear for their safety or to suffer substantial distress. It also protects the affiliated, quote, affiliated individual of the victim. So immediate family or any individual living in the household. That I've had cases where, you know, like it affects the children of the victim or the sibling who lives with them. So situations like those. So it applies to both application and admissions to a federally subsidized unit, and also termination and evictions once someone is already in a unit. So in the application process, the housing authority or the landlord or the owner of the unit can't deny an application on the basis that the applicant is or has been a victim of domestic violence, dating violence, sexual assault, or stalking. Monique gave a good example earlier of a landlord saying they won't rent to a victim of domestic violence because they always return to the abuser, or it's going to be, maybe they think it's going to be drama because the abuser is going to come, or this person's being stalked and they don't want to deal with someone who might have to call the police and, you know, disrupt other neighbors. That is all not legal for a tenant to be denied based on those reasons. In terms of terminations and evictions from the tenancy, the landlord, owner, housing authority may not evict a tenant on the basis that they have been or is a survivor. They can't evict because a crime against a survivor or that's directly related to that abuse has occurred on the property. So like even you know, I've had cases where someone was being abused on the property and neighbors heard that abuse happening, and it would be maybe like wake them up, or it would disrupt the, you know, their day or whatever, and they were complaining to management, and then management would attempt to evict the victim on the basis of like that sound bothering neighbors, and I would argue that's certainly not legal under the Violence Against Women Act. So there are some situations where the housing provider could still attempt to evict the survivor of domestic violence. They would have to, in order to do that, demonstrate an actual and imminent threat to other tenants or to employees at the property if the survivor is not evicted. So actual and imminent threat is really, really fact specific. There's no definition. I couldn't tell you exactly what a situation like that might look like if you have a tenant who might be in the situation where they're being evicted for actual and imminent threat. It really is just going to boil down to the specific facts of that situation. We do know that a threat consists of physical danger that is real, would occur within an immediate time frame, and could result in death or serious bodily harm. Factors that should be considered but are not dispositive are the duration of the risk, the nature and severity of the potential harm that would be caused, the likelihood that the harm will actually occur, and the length of time before the harm would occur. So an eviction in this case really should be the last resort. It should only occur if there's no other action to be taken that would reduce or eliminate the threat. So if you can show that, you know, there is some other action that might reduce or eliminate the threat, then eviction would not be the appropriate next step. Something a housing authority or a landlord can do is sometimes they might bifurcate or split the lease. If there's a lease where there are two folks on there and one person is abusing the other. So they could split the lease to evict the the abuser while allowing the victim to stay. There are protections for the tenants remaining in the person who remains in the housing after the bifurcation. An issue we run into a lot here is that sometimes someone was relying on the abuser to help pay the rent or pay half of it or sometimes all of it. And once they're forced to leave, there are protections for the remaining tenant, but it can get really difficult to afford that apartment if they were relying on the other person financially. Let's see. So yeah, so there's a lot of protections essentially for the remaining tenant. And the landlord still needs to follow federal, state, and local law when evicting the abuser. They can't just kick them out. There are ways to get like a move out order through a domestic violence restraining order. That's a slightly different process. If it's the landlord trying to get rid of an abusive tenant, then they do need to follow all the eviction laws. So other actions that the housing authority can take. Housing authority can terminate a Section 8 assistance to the abuser while preserving assistance to the survivor. So kind of like what I was talking about earlier, like in separating the lease or taking off the abuser from the lease, they could provide assistance then only to the remaining tenant. Yeah, so if a Section 8 voucher family moves out in violation of a lease, the housing authority has grounds to terminate the subsidy, but VAWA does provide an exception for a survivor who needs to move out for their safety. So again, if someone needs to break a lease because of abuse, they can do that, is essentially what this boils down to. There are also these things called emergency transfers, and these are all things we help with. If you have a tenant who's experiencing something like this and needs to move, needs to break a lease, is being abused, or they need to be transferred to another unit, we can definitely help with these things, and you can refer them to Bay Legal. Survivors living in federally assisted housing, they might need to move or transfer to another subsidized unit to protect their safety, but also to keep that subsidy. We've seen that happen just within Contra Costa Housing Authority public housing units. Maybe someone was living in Rodeo and their abuser knows where they live and comes by there all the time. So they can request an emergency transfer to be moved to Antioch. So where it's a lot further, the abuser doesn't know that they're going to be moving. It might just be better for their safety. And so under VAWA, they can request an emergency transfer like that. So each housing authority is going to have outlined in their plan how to request that transfer. But essentially, the tenant needs to expressly request the transfer and show that they believe that they are being threatened with imminent harm from further violence, or the tenant has been a victim of sexual assault that occurred on the premises within 90 days of the request. So the transfer plan also needs to ensure the confidentiality of the tenant. The housing authority, of course, should never disclose the location of the new unit and where that tenant will be moving to the abuser. Here's a quick hypothetical. So Tessa tenant lives in subsidized housing in Antioch. On September 1st, she was attacked by her abusive partner in the front lobby of the apartment complex. On September 3rd, her landlord serves her with an eviction notice because of this altercation in the lobby. Can the landlord evict Tessa under these circumstances? A, yes, because the altercation is considered a lease violation. No, because the acts against her constitute domestic violence. And C, it depends on whether her housing is covered by VAWA. What do y'all think? You can put it in the chat. I'll take a second and I will not reveal the answer. I'm seeing a lot of B's, which looks great. Let me just quickly ask, why not C?
Depends on if the client came in there under that act.
Yeah, so we want to see under C, whether the housing is covered by VAWA. And we talked about how subsidized housing units are covered by VAWA. So since Tessa Tennant in the first line of the hypothetical says she lives in subsidized housing, we're assuming here that yes, her housing's covered by VAWA. And I think that's why everyone was voting B here. Definitely cannot evict because of this attack that occurred on the property since she was a victim there.
Abby, there's a question in the chat, and also people have their hand up for questions.
Oh, thank you. Let's see the question in the chat. What if you use all of these options and you never received an answer from Housing Authority or HUD and your life is at risk and you send in all the evidence? What's next? Why is Housing Authority not held accountable? Yeah, that's really terrible. Really, really terrible. I would hope this person can get assistance from Bay Legal. We've seen situations like this. It's not what you're asking is like definitely, unfortunately, not something that doesn't happen. So I think we'd want to help. We'd also, they could, I would want to help them file a HUD complaint with the agency. Like Monique was saying, you can file a HUD complaint against a federally subsidized unit. Online, it's super easy to file the complaint for discrimination, and I think allege discrimination, depending on the situation.
It's important to recognize that even though we often hear people refer to the Housing Authority as HUD, the Housing Authority is not HUD. They receive their money from HUD, which means that if somebody complains to HUD about the Housing Authority, they might pay even more attention about an alleged fair housing violation on the part of the Housing Authority when the Housing Authority itself is getting all of its budget from HUD.
Yeah,
So
thank you for that distinction.
Something to sort of think about there.
Thank you, Mom. Thank you.
Let's see. I see Lucinda and Darlene, your hands are up. Were there other questions?
Yeah, I have a question. Now, going back to what you just said about this scenario on the screen. Unfortunately, this doesn't fall in place in Contra Costa County. I'm just going to be honest. This doesn't fall in place in Contra Costa County because this has happened in Contra Costa County. And unfortunately, the person was taken off of the voucher, but both parties lost the voucher. And the Contra Costa Housing Authority did not help the situation any better. It made the tenant it made the victim spiral down. And mental health kicked in. Mental health was a big part. Losing their family was a big part. I mean, it didn't help the situation any, or did it resolve the issue and helping the client at all? My main concerns is HUD and housing. They are doing their part as far as helping the families keep their home or help them separate themselves from a domestic situation, a domestic violence situation. Why is it that I understand we under this COVID epidemic and everything like that, but why is it so hard for them to just reach out and talk to the victim or whoever the case may be, legal advisor or whatever the case may be? Because at the end of the day, they're not suffering, the victim is, and the victim is still losing at the end of the day because they end up CPS to step in. Why? Because the victim spiral down, mental health, or no housing for the children, or whatever the case may be. There's a lot of things that come into play legally far as towards the victim, and the victim is being accountable for it because why? Because they was kicked off of housing because housing did not want to step up and do their part. I'm just throwing that scenario, not that scenario, that actually event actually happened. And now the person is without housing, and now they gotta go through the cycle all over again. And the housing is not even being accountable for their actions, for not even trying to step up and help or find out or talk with the victim that it took place with. It's just crazy. I'm just asking a question to them.
So I think I agree with everything you're saying, that it's really like housing authority is often, they hear about a lease violation or what they think is a lease violation and they are quick to evict. We see that in public housing all the time, or yeah, in like different subsidized units where they really don't seem very understanding or interested in hearing from the tenant, which is really awful, especially in situations where there's abuse. We all know that abusers might not immediately jump in to say, like, you know, I'm a victim of abuse. They might not realize, or it might just be uncomfortable, or they might feel some shame around it, or there might be some reason they're not sharing that immediately. And when a landlord gives a 3-day notice or a 10-day notice or a 30-day notice, that might not be enough time for the victim to feel comfortable or able to discuss what's going on. And so it's really not ample time to like raise this as a defense. And I think the housing authorities counter argument to this situation would be that if they're not told that it was domestic violence, they have no way of knowing. They don't know that there's a victim to protect, you know. So
They
I
have
think,
the evidence that, excuse me, I don't mean to cut you off. They have the evidence and they knew about it because they had the police report.
yeah, so even in situations like that, so they're just anxious to evict and not really trying to be advocates for the tenant. And I would hope in those situations, I think like we've been able to have success representing those tenants and forcing the housing authority to follow the law and do what it's supposed to do to protect victims. But even in certain cases where, like you're saying, it's so clear what happened, they're still dragging their feet on initiating an emergency transfer or doing what they need to do. And it's really frustrating. I agree with you. It's not okay. And I think the purpose of this training is we don't have the power here right now to fix the housing authority and the way they do things. We can't control them, but what we can do is train ourselves to see these situations and recognize it immediately and know that we need to jump in and advocate for someone who otherwise housing authority might just steamroll or take advantage of. So I hope this is helpful in that regard, that it's helpful that to folks that might not be as familiar with these situations to do issue spotting and know when to refer to legal aid or to jump in and help with a administrative complaint. Were there follow-up questions? I see your hand up.
Abby, so let me lower my hand. This is my last question. So so even when you're using legal advice or using legal actions along with what took place, and housing authority still doesn't do it, how is it, what helpful is housing authority? Understanding housing authority is a blessing for most people, and I understand that, but they're not they're not being accountable for their actions, especially the person. It's not the agency itself, it's the person that's behind the desk. So especially the person behind the desk are not doing their job or not following the guidelines or following up or finding out. How is it helpful? It's more hindering than helpful for the client.
Yeah, I agree with you. I think that is where my job and Monique's job comes into play, is a lot of times what we're doing is just holding landlords or other agencies accountable and making sure that they follow the law. And when they don't, we threaten some kind of recourse or try to force them. So that is kind of like the hole we're trying to fill there. But I know even sometimes we do our best and we're unsuccessful as well. But I'm going to move on. I think these are great questions, or great just kind of like issues to raise. And we can talk more at the end for sure. I just want to make sure we have time to get through everything. So I'm going to keep it pushing, but thank you so much, Darlene. So I'm going to shift a little bit to talk about disability discrimination under the Fair Housing Act and how we can protect the rights of people with disabilities to be able to live in and enjoy their units just as someone without a disability would be able to. So under the Fair Housing Act, it is against the law for the landlord or for a property manager to ask a potential tenant about a disability or current tenant about a disability unless the tenant is requesting an accommodation or applying for a housing that gives priorities to a person with disabilities. So the manager couldn't say, if the tenant didn't ask for a first floor unit, the manager couldn't say, oh, it looks like it's hard for you to get around or whatever, like I'm just gonna offer you a first floor unit. That would be illegal. They can't refuse to reasonably accommodate a person for disabilities. I'll get more into reasonable accommodation in a moment, but they can't just flat out refuse a request to accommodate. They would need to engage in some interactive dialogue, try to figure out a reasonable alternative solution if they really can't accommodate. They don't need to, they're not allowed to ask a tenant to provide more documentation than is necessary to verify a disability or a need for accommodation. Sometimes we see landlords that really don't want to grant an accommodation. So what they'll do is ask for records, and then they'll ask for more medical records, and then they'll ask for a letter from a friend or a letter from a therapist, or, just like on and on and on. And it's clear that it's because they just don't want to grant the accommodation that's being asked for. A property manager or a landlord can also not ask a disabled person to prove that they have the ability to live independently. That is not okay. So I kind of touched on this, but some examples of intentional disability discrimination would be steering a person to a certain building or a floor based on a perceived disability. Saying, oh, you don't want that unit by the pool because it's too noisy and you won't even use the pool anyways. So that could potentially be disability discrimination right there. Offering different terms, conditions, or privileges of tenancy to different tenants is an example of intentional disability discrimination. So like making someone pay a higher deposit if they have a motorized wheelchair, but not for manual wheelchairs, walkers, or canes, or like a sign in the lobby that says no wheelchairs in the lobby. That's certainly disability discrimination because that would mean that someone who needs to use a wheelchair just couldn't access the lobby as another tenant would. So requesting a reasonable accommodation, this is also something we do a lot of in our practice. And if you have someone who wants help requesting one or has requested one and received an inappropriate response, you can definitely refer that type of case to Bay Area Legal Aid. What is a reasonable accommodation? So let me back up a little bit. A reasonable accommodation is when a tenant requests a change in a rule, a policy, practice, or service, and this could be written in the lease or not. But they request a change in that rule or policy that's necessary to allow the person with the disability the equal opportunity to use and enjoy the dwelling. A disability is a mental or physical impairment that substantially limits one or more life activities and or a history of such impairment and or regarded as having an impairment. The asterisk here is California law does not require a substantial limitation. That's the federal requirement. So essentially, if someone has a disability, they can request a reasonable accommodation to enjoy the unit or use the unit the same way anyone else would. How to request a reasonable accommodation. So reasonable accommodation, there's no magic language or magic words you need to say to make that request and to have it be a valid enforceable request that should be taken seriously. It can be requested verbally, can be requested in writing. We always, when we help folks with one, we do it in writing just so there's a paper trail. The landlord can't claim in the future that they never received it or never heard about it if we have a record in writing. The accommodation request must have a quote nexus to the disability. So what that means is the accommodation that's being requested must be somehow connected or have a nexus to that disability and be necessary for the person with the disability to use and enjoy the unit. So the best practices here are to make the request in writing and also provide verification from a knowledgeable professional if asked about it. So the tenant, when they make the request, they don't need to come with medical records for that request, but if it's something where they think they might need to prove it, it's good to have those things ready. They can have something from a professional that says this impairment substantially limits major life activity. And it can also talk about just generally the need for that accommodation. When can a reasonable accommodation request be denied? It can be, but there's very specific situations where it can be. Under state and federal law, a housing authority or housing provider, excuse me, must provide the accommodation that's been requested unless the requested accommodation has no relationship to the person's disability. The two things don't have a nexus, they are completely unrelated, or providing the requested accommodation would fundamentally change the nature of the provider's operations or would impose an undue financial or administrative burden or create a direct threat. So, that could be an accommodation request that is extremely expensive or burdensome or there's a lot of examples, but things that are impossible. Like if someone requests to have an elevator installed in a unit where there's no elevator, I think often that would be seen as not reasonable because that's super expensive. It's a huge undertaking and endeavor. So let's talk. If the housing provider believes that the requested accommodation is not reasonable, so like the example I used of the tenant requesting that an elevator be installed, then the provider is required to engage in what's called interactive dialogue with the tenant to get more information about the disability-related need and find a reasonable alternative accommodation. So if they think what the tenant is requesting is way too expensive, way too burdensome, or they don't understand how it's related to the tenant's disability, how it would help them better enjoy or use the unit, then they can't just say no, like, no, we won't do that, or no, we won't help you. They need to engage and say, you know what, we can't do that for this reason. Is there another thing we can do? Here are some other ideas of something else that might be able to work to accommodate you. Or if they don't understand the relation to the disability, maybe they might ask questions around that. How would this accommodation help you live in the unit? Can you provide more medical records? Whatever the next step might be, but they do have to engage in that interactive dialogue. So, talking about accommodations and other rights, again, I want to really stress that the RA stands for reasonable accommodation. It does not need to be in writing. Knowledge of need for accommodation may be enough to trigger the owner landlord's responsibility under the Fair Housing Act. The verification of disability doesn't have to come from a doctor, and medical privacy rights are still protected by HIPAA. So what this means is a lot of folks think that they have to have a note from a doctor verifying their disability, but it actually doesn't need to be from a medical doctor. It could also be from your therapist, psychiatrist, psychologist. It could be just from a neutral third party, someone who's a reliable third-party source who knows you really well. An example we use a lot is it could be your pastor that knows that you struggle with anxiety and would benefit from whatever accommodation you're requesting. Landlord cannot share this information with outside parties in violation of HIPAA. Also really important to include here, if you request or a tenant requests a reasonable accommodation and the landlord just doesn't respond, that non-response in itself is a violation of the fair housing laws, and the tenant, the likely best next steps would be to file a HUD complaint against that landlord if they just don't respond, because we can assume that that's a denial. I want to also make the distinction between reasonable accommodations and reasonable modifications. A modification is a request for a physical change to the unit. It must be requested, and the landlord is not required to pay for this modification. The tenant does not have to pay if it's a HUD subsidized tenancy, however, then the tenant won't be liable. And then after the tenancy ends, the property needs to be returned to its original condition at the tenant expense. So, and that's in private housing. So like an example would be in private housing, if you want to install grab bars in the bathroom, those bars near the toilet that help folks move around the bathroom. And this person's in a private housing unit, they don't have a HUD subsidy, then they can request that modification. That would be a modification because they're adding the bars. That's a physical change to the unit. And if the landlord approves, they would need to pay for that themselves. Then when they move out at the end of their tenancy, they would have to pay to remove those bars. It would be totally on the tenant, not on the landlord, because that's a modification and not an accommodation. So got some hypos. First one, true or false? Someone with a mobility impairment can request a parking spot closer to their unit as a reasonable accommodation. True or false? Oh, I see in the chat we were talking about the handrails in the bathroom. That's funny. Okay, yeah, true or false? You can request a parking spot closer to your unit. True, yes. Okay. See, a couple people said true. Just in the interest of time, I'll keep moving. I know not everyone got a chance to answer, but yes, you can definitely request a parking spot closer. This is usually, I mean, every situation could be different, but this seems to me like something that would not burden the housing provider very much to approve. And yeah, should be pretty inexpensive for them. I don't see a problem unless, I mean, there could be like, I guess, some construction issues, or if there are no available spots, I'm not sure. Okay, number 2, someone who has a hearing impairment can request a parking spot closer to their unit as a reasonable accommodation. Yes or no? So in this case, it is not very clear how a hearing impairment will be related to a closer parking spot. The nexus here is very unclear if it's here at all. The next step would be for the provider to come back and ask more questions about the nexus, to engage in that interactive dialogue I was talking about, to try and see if there's something else they can do, or if there's, you know, like what this is about. But I think if the tenant can't make a solid connection between their hearing impairment and how having a closer parking spot will help with their hearing impairment, then the landlord could probably deny this request. Let's do the last one, number 3. A person with mental health impairment received a notice of lease violation due to symptoms of his or her disability. This person can request that the notice be withdrawn as a reasonable accommodation. What do you guys think? I see one person says true. Oh. See a couple trues, couple no's. All right, so yes, the person with mental health impairment, this one is tricky, received a notice of lease violation due to symptoms of the disability. They can request an accommodation that the notice be withdrawn. Yes. A landlord might be able to say no in certain situations, maybe even if it is disability related, if what the tenant was doing caused harm or cause an imminent threat to employees or to other tenants, that might be a reason for the landlord to deny this request. But we often have cases like this, and we do have success getting eviction notices withdrawn because we are able to point to the mental health issue that caused the lease violation. And these are examples too of when it really makes sense to jump in and advocate for a tenant who maybe housing authority or their landlord doesn't know that they have mental illness that caused them to act a certain way. In best case scenario, you can explain that and help get the notice rescinded. Sometimes the landlord still doesn't want to, but that's kind of where Monique and I would jump in. I just have quickly some more common examples here. Client needs a ramp to access the entryway. That would be a modification because you're adding a ramp. It is construction to the unit. Client needs an emotional support animal, but pets are not allowed. They can request an accommodation to allow their support animal, even though there's a no pet allowed policy. Client source of income is Social Security. Monique talked about this one. The SSI check comes on the 6th, but the rent is late on the 5th. You can ask for an accommodation to change your rent due date. And this one, a lot of landlords don't want to, but I think it's very reasonable to request this. Clients' disabilities make it difficult for them to move within the eviction notice period. Reasonable accommodation for more time to move. These are super common as well. How is fair housing enforced? We've talked about this a lot. If fair housing laws are being violated by a landlord, whether it's discrimination, what have you, the tenant can file an administrative complaint with HUD, DFEH, which, like Monique said, as of last week has a new name, something civil rights, I can't quite remember, or the Department of Justice. And it's really easy to do those complaints. You can do it online. It takes a few seconds. If someone doesn't want to use the computer, you can do it by phone, also very quick and easy. And then it triggers an investigation. They can use these things as a defense in an unlawful detainer, which is the eviction lawsuit. Or someone can just get a private attorney and sue their landlord or property owner in a civil lawsuit for damages and injunctions. I will pass it off to Monique. We can pause maybe briefly for questions, although we don't have too much time.
Abby, you just muted for some reason. Abby, we can't hear.
Oops.
Oop,
Okay,
there we
here
go.
I am.
Okay, there we go.
Sorry, I wanted to see if there were any quick questions before we move on. Laverne, I see your hand raised.
Hi, I do have a question, and it's about the reasonable accommodations for emotional support animals. Can you guys, I don't know if this is actually the forum for it or if you're going to have something separate, but really expound on that, because we tend, we're in Alameda counties, or one of our service areas is in Alameda County, but all over the counties, a lot of our clients have emotional support animals as well as service animals. And so trying to get them to provide documentation to places that they accept pets, but may have weight limits or breed limits. How do we support our clients around that?
Yeah, so just like any other exception to a rule, if they have a dog that is too big or too heavy or the wrong breed, they can certainly ask for a reasonable accommodation. They probably will have to show some type of documentation, but like I was saying, it doesn't necessarily need to be from a medical care provider. It could be from another reputable third party, just saying the reason and that the person needs it, and illustrating that nexus I was talking about between exactly what the disability is and then why you need the animal to help live in the unit and enjoy the unit the same way another tenant would. So it's the same analysis I discussed, just with the rule you're hoping to change is the weight limit or the breed restriction. And again, if a landlord just flat out denies it, then that is a good basis for a HUD complaint, I would say.
I'm gonna,
Another quick question with that, sorry. So if they say they provide documentation, and this is a scenario we've had, they've provided the documentation to show that they have, that they are emotional support animals, but the documentation only mentions one animal. Do they have to have documentation for each animal that they are considering as emotional support, or is the one sufficient for all of them?
So you do need documentation for each animal, but you are allowed to have more than one animal, certainly. And I think Monique had something to add on to your first question.
no, I'm trying to answer a question in the chat.
Okay.
I mean, I think it's really complicated. In any reasonable accommodation, the landlord and the tenant can go back and forth about whether it's reasonable. So I remember several years ago, we defended a tenant who was being evicted from a mobile home because of her support animal, and the support animal was considered to be a pit bull. And in the end, the jury decided at the trial that the landlord was right, that they had a right to evict the tenant, even though an animal rights group and a disability group had helped us prepare for the trial. In that case, the landlord brought in neighbors to say they were afraid of the dog. And so I'm not saying I per se agree with that decision, but what I'm trying to explain is that it can be very complicated in terms of the facts when there are disputes about the nature of the animal.
Yeah, I think that's really important to remember too, is that all of these things are very fact specific, and it's going to be, at the end of the day, humans deciding what's reasonable. If it becomes a dispute and if it ends up in court or investigated by HUD, there's still going to be a person deciding at the end of the day the reasonableness. So while I might take the stance that something is perfectly reasonable just because I think that and I advocate that for my client, it doesn't necessarily mean that we will be successful. Hopefully we will be, but it's not guaranteed.
Thank you.
Okay,
You're
we're
welcome.
gonna, Eugene, the whole, yeah, you're right. Service animals have a lot more protection than emotional support animals. Essentially, if you can show that you have a service animal, the landlord cannot refuse the accommodation. I think that there was a recent case where an airline could refuse to allow emotional support animals. I don't think that's true for landlords, but I would have to research that for you. Abby, I know that the airlines can refuse to let you bring on your emotional support llama onto the plane. But have you heard anything in terms of landlord tenant law about the differential between an emotional support animal versus an actual service animal?
Yeah, so service animals are like a step up from emotional support animals, but exactly like Monique was saying, there's been a lot of kind of like talk about this because of the airline thing. But housing is different, and a landlord could say that no, you can't have your emotional support animal because it's too big or the breed or whatever, but would still need to engage in the interactive process to figure something else out. The llama, yeah, so they would still need to engage in the process. They wouldn't still wouldn't be able to just do a blanket denial, like kind of as the airlines are saying that you can only bring a service animal on, not emotional support. I hope that helps, and let's move on. We can talk more at the end with free time we have.
Okay, so there are some changes in the law in the last couple of years that we wanted to make sure that folks knew about. The next slide talks about source of income. We've had source of income protections for years. I couldn't refuse to rent to you because you have SSI. But in reality, that hasn't come up very much because the amount of rent at this point is so much in most of California that if your income is SSI or CalWorks, unless you have a Section 8 voucher, you can't afford the rent. It's okay for a landlord to say, I don't want to rent to you because you have bad credit. It's okay because I don't think you have enough money. However, as of January 1st, 2020, that umbrella of protection was expanded to say that landlords are not allowed to refuse you just because you have Section 8. And a VASH voucher is a specific type of Section 8 for veterans, and any other forms of rental assistance that might be from a county or a city. So this plays out in many, many complicated ways. Landlords are coming up with all kinds of creative ways to continue to discriminate, but pretend not to, so that a tenant with Section 8 will be told, oh, well, I only signed 6-month leases. It could be true. On the other hand, it could be because that landlord is aware that HUD regulations require the first beginning of a new Section 8 tenancy to be a 1-year lease. So it's hard to know if a landlord is discriminating when they're coming up with these workarounds, but we're seeing a lot of it, and it is illegal. If you look it up, you can read California Government Code 12955, which spells out all the types of discrimination that are illegal in California. Again, this is also applicable to employment law. And if you look at it, it's got a lot of sections. When you get down to like sections O, P, you begin to see these newer changes to the law where your Section 8 voucher, the landlord theoretically is not allowed to discriminate against you because you have Section 8 or a HUD VASH voucher, very similar. And Abby can go on to the next slide. And the other thing I want to mention before I forget is part of the way this plays out is the landlord is not allowed to say, oh, well, the rent's $2,000 a month, so the minimum income for this family to be able to rent this apartment has to be $6,000, 3 times the rent. That's okay, except if you have a voucher. The landlord math has to be, okay, the tenant's share is $600 a month, so the tenant's minimum income has to be at least $900 a month. So I think most people with this training are somewhat familiar with the fact that if you have a Section 8 voucher and your income goes up or down, your share of the rent goes up or down. But we're talking at the beginning of the tenancy, the landlord is not allowed to refuse to rent to you if you have a voucher because, oh, well, your income isn't $6,000 a month. The rent's $2,000 a month. We require 3 times the income, 3 times the rent in family income. Well, that's not true in case of Section 8, and there's a specific provision spelling that out in California Government Code 12955. So here we have a hypo. Tina tenant is looking for a place to rent on Craigslist. She finds a listing she's interested in, but the listing says no Section 8. She also has poor credit. Regardless, she applied for the housing, but she is denied when they learn she has a voucher. And the question to answer in the chat is, can the landlord deny her housing based on the fact that she has a voucher? And that would be A, B, or C. I'm seeing a lot of brilliant experts in fair housing correctly answering this question in the chat. Because Section 8 is seen as a source of income in a way under the government code, they can say, I don't want to rent you because you have poor credit. But here in this hypothetical, they are saying they don't want to rent to her because she has a voucher, and that is illegal. And she could go to the formerly known as Department of Fair Employment and Housing, DFEH, now known as the Commission on Civil Rights, and online file a discrimination application. The other thing she might consider is maybe writing back to these friendly people on Craigslist and saying, that's illegal housing discrimination, and see if they're suddenly more willing to consider her application. Next slide. There's also protections for people who are immigrants. Landlords are not allowed to ask about immigration or citizenship status unless the landlord itself is required by federal law to ascertain the immigration status of the family. So for example, in public housing, you can have some people in the family who are undocumented and some people are in that family may still qualify for subsidized housing, but the amount of rent they pay is different because the income of the undocumented members is calculated differently in terms of determining the rent. That would be, Irma, illegal housing discrimination. It's like, I don't want to rent to you because you're a Catholic. I don't want to rent to you because you're a lesbian. I don't want to rent to you because you're married. I don't want to rent to you because you have Section 8. It's not legal in California to say that anymore. And that's also true in other places in the country. It's illegal housing discrimination to say, I don't want to rent you because you have a voucher. Anyway, going back to the protections for immigrants, a landlord is also not allowed to threaten you to turn you into ICE because you're an immigrant and they're mad because you're complaining about habitability and you want them to make repairs. The law specifies that the tenant or person applying to rent somewhere cannot be required to make a statement, representation, or certification about their immigration or citizenship status. Again, there are exceptions for subsidized housing under federal law where there are certain programs where if everybody in the family is undocumented, it is unlikely they will qualify to live in federally subsidized housing. In Eugene's question, I would say that's completely illegal unless we're talking about Section 8 or public housing. If right on the application to live in private housing is a question about whether or not someone is quote unquote legal or illegal, no person is illegal, but you know, the landlord may phrase it that way. That's illegal in California. They can't do that because of the law we're talking about. Next slide. So here's our hypo. Tammy tenant rents a studio from the landlord. She has a green card. During the tenancy, she required a lot of repairs. She gave notes, emails, text messages to the landlord. They didn't respond. After 3 weeks, he said, I'm going to send somebody. Nothing happened. She reminded him. So she contacted code enforcement in that town, and code enforcement investigated and issued a notice to the landlord that they had to make certain repairs. The landlord got really upset, accused her of being undocumented, and says she has to move out immediately and go back to your country. And he sent her a text message threatening to contact ICE. Is this unlawful retaliation or discrimination? Again, in the chat, true or false? I think you're all fair housing geniuses. You should do the training. Yes, this is unlawful retaliation and discrimination. And I'm not sure if that's what, yeah, sorry, I'm switching gears a little bit now. Please tell people to call us if they have any questions, even if somebody asked a question earlier about somebody who lost their voucher because they were the survivor of domestic violence and everybody was forced to lose the voucher despite what HUD regulations are. That person should still call, even if the voucher was lost some time ago. It depends on how long ago and what are the very specific facts in that situation. So the 800 number is our legal advice line. As Abby already said, please encourage your clients to call at 9:30 in the morning if they possibly can, especially around housing. We get so many calls. We want to help everybody. And I'm not sure we're able to help everybody, but the person who calls at 9:30 is more likely to get through and get some good legal advice from our legal advice line. And I think we have one more slide. Oh, time for questions. So I'll shut up. And Mr. Carter, did you have a question?
Yeah, I work as a housing navigator currently, and I see a lot of these barriers with trying to house clients. You're talking about the 3 times rent. And although I work with a younger population, I would imagine for somebody on Social Security with a fixed income, that could be quite difficult to get past that barrier. But I'm also seeing things like I had asked earlier about them asking about third party and they say no. Or even a lot of these subsidized housing programs, I believe, have program agreements that have to be in place with the landlord and the client. And sometimes the landlord will just say, no, I don't want to agree to that, as a way of saying no. I guess what I'm wondering is, what can we do as frontline workers to increase the chances and remove these barriers for our clients to get housed, and what on a policy level or legal level might be done as well to improve their chances?
I would say maybe spelling out how you believe the housing provider is acting in a discriminatory manner. I would have to know more about the facts if the third-party payer. Abby, it's hard for me to imagine a program where it would be legitimate for the landlord to refuse to rent to somebody because the rent is coming from a third-party payer. But I can imagine a scenario where maybe there's some sort of special program requirements. I would say the tenant has always the option, or you can assist them going to the website of the California Commission on Civil Rights, easily found by typing in California Department of Fair Employment and Housing, or HUD, and doing an online administrative complaint. And after that's done, maybe communicating to the prospective landlord that that's been done. It'd be good to call the legal advice line if possible, and somebody go over the fine-tuning facts here. I would say if the carpet is coming up and pulling away from the walls and it's a tripping hazard, I don't care if they lived there for 2 days. That's not a safe environment. The landlord is breaching the implied warning of habitability. Unfortunately, the law does not require the landlord to repaint or to give you a new carpet. So a lot of people are really unhappy about their old funky carpet or the way the paint is on the walls. It is hard for me to see that as a landlord obligation. Unless, as your example gives, if the carpet is coming off and the people are potentially going to trip and hurt themselves, obviously that's breaching the implied warning of habitability. You're not supposed to have flooring that's so unsafe that people can get splinters or trip and fall because of the flooring itself. And
Samantha, did you have a question?
Hey, thank you guys for the presentation. I've had to be on a few, I don't know, SOS calls, right, with landlords, so I had to excuse if this are already discussed. Sometimes we help in, prevention and keeping someone in a unit. And with Cal COVID rent relief, right, where there's a promise to the landlord that they will be paid, and yet they proceed with an eviction anyway, or they proceed with what maybe it could be called harassment. I'm not sure, but they tell their tenant, well, here's your 3-day notice. After making a letter of intent's been supplied, maybe we're waiting on their W-9 after they've agreed to let us as a third party pay for the tenant to remain in the housing. Are there any thoughts or any cases that have happened with, are they allowed to do that? Just that they don't have their money, so it's done? Or is there more protections that we have in Contra Costa regarding that?
I'm trying to think what exactly, Monique, interrupt me if you know better right now. I do think still if there's like a pending ERAP application, then we can stay the eviction until then. Monique, is that incorrect? I would have to look and see exactly.
I think that's still true. If the landlord is suing the tenant for rent that was due before July 1st, and there's a pending ERAP, Housing is Key application, ERAP is Emergency Rental Assistance Protection. The problem is that there's been a lot of slowdown since about a year ago. Since about March or February in the processing of applications at the Housing is Key website. Maybe they just didn't have the staff, and there was a big last minute surge of people trying to get this money. And so there's actually been lawsuits filed, one in Southern California, one in Alameda County, where nonprofit groups are trying to get what's called a writ of mandate. And a judge on July 8th in Alameda County issued an order to Housing is Key, which is run by the California Department of Housing and Community Development, that they have to go back and look at pending applications and denials. But that doesn't necessarily mean that everybody is going to be able to resolve things. I was recently following up on somebody who'd already gotten the maximum amount of money, and they may not have understood that, and maybe their landlord didn't understand it. I think there's still evictions that are on hold because large corporate landlords are getting a lot of this money. There's so many fact patterns we've been hearing for months. I don't know, Abby, did you want to say anything else about housing is key?
No, I think like we can try. I think that's like a very good argument to try and hold off the eviction, and it's something we'd want to look at, but it depends, like Monique was saying, when the rent was accrued. If they've already received emergency rental assistance, that can play a part. And then we can talk to Housing is Key too. We've had cases where we just need to follow up and see like what exactly is missing from the application and why it's still pending. So they can be really fact specific. There's not like a no, these can't be filed right now. Earlier in the pandemic, there was like more protections upstream, I would say, like from it even being filed or being permitted to like proceed in court. And there's not that currently.
In Contra Costa County, there are still really sturdy protections in Alameda County. We're very focused on Contra Costa County. There are also very strong protections right now in Richmond. But in general, in Contra Costa County, the landlord can sue you for whatever they want. I'm putting the name of a judicial council form in the chat. It's called the UD 125. It's very specific, but if the landlord is trying to evict a tenant for rent and they got an approval from Housing is Key, theoretically, if they've lost the case or they're in the middle of fighting the case, they can use this form. You can again just go onto the internet and type California Judicial Council, which makes a lot of legal forms. It's actually the state Supreme Court's, it's a subpart of the California Supreme Court. So this isn't just some company called the Judicial Council. It is the state of California. And a UD 125 form might help a tenant assert their rights to the court in an eviction for rent where there is an approved Housing is Key application. And trust me, the commissioners who are hearing eviction lawsuits in Contra Costa County right now are very familiar with some of the scenarios. Thank you all for being here, and we have 5 more minutes for questions. Don't forget our survey, which is higher up in the chat. This question, yes, I would say that the person should send a lot of letters to the landlord. Document this, save copies of the letters, emails if they have to, if they're not comfortable with written letters, because you certainly have a right to make your unit safe and healthy, and the landlord should be paying for it. But if nothing else here, you should be able to fix the carpet yourself. Ideally, what you want to get is the landlord's agreement. There's a concept in landlord tenant law called waste, which I don't want to go into, but technically you're not supposed to change the landlord's property. On the other hand, if the carpet is a tripping hazard, you're also not supposed to break your neck because the landlord's too cheap to fix the carpet. Abby, can you think of anything else that would address my carpet is a safety hazard and my landlord's too cheap to fix it scenario?
No, I can't think of anything else. That's a really hard one. I get a lot of tenants with like really dirty carpets and they want it cleaned. And unfortunately, I think that is a thing that falls under tenant responsibility. But also, yeah, if there's like nails sticking up or if it's become dangerous, that I think you could argue is landlord responsibility. Jamie, I can send you this updated training too, if that would be helpful.
Normally, if there's somebody who's on the voucher, not somebody who's merely visiting the tenant or is an in-home care provider, but if somebody is part of the voucher family and the head of household dies, there's a concept in federally subsidized housing law called remaining family member. So normally the remaining family member would become the person who would have a right to the voucher. Again, it's very fact specific. Is this person on the voucher household? Or are they, again, the in-home care provider? That's very common. People apply to have their spouse or significant other or their old, their adult child become the in-home care provider. that person is not necessarily a remaining family member. We're
Thanks
glad
so
you
much,
liked it.
everyone. I know this is such a dense training and there's so much, and I don't expect anyone to remember any of it. I think most importantly, if you take anything away from it, it's our intake phone number. I think it's always good to call and get information, even if you're not sure it's something we can work on or not. Legal Advice Line is a resource that's free and really helpful. And so your tenants or folks you work with can always call to try and get information. And if they can't help, they can likely provide a referral to another organization that can, or just kind of like point in the right direction. So it's a good place to start when all else fails. Erin, I see your hand up. So in this like situation, did the landlord evict the abuser? I guess I would want to see the exact basis for that denial. And I imagine they would have to put that in writing. If they have some kind of like, if they're using, like, so we talked a little bit about criminal history. If he was arrested and convicted of something violent within 7 years, maybe that's a reason to deny that's lawful. But if it was more than 7 years ago, or if it was an arrest that did not lead to a conviction, or if it was expunged, then he might be able to make the argument that they can't consider that history. So I'd be interested in seeing exactly the basis they're using for the denial. And if he was evicted from the property, then they could use that. I'm sure, like if he was evicted for violence or threats of violence, or, you know, causing harm to tenants on the property.
Although
So.
I certainly want the person who was the survivor, if they're comfortable with still being with that person, to go back to the landlord and say, you know, you said that Harry had to move out, but actually Harry went to family violence training therapy, and we're back together and we want to live together, and I'm a survivor of domestic violence and I want to assert my rights in this different way. I'm not saying it would work. It would be very fact specific. Did he, it's 3:01. I know some folks need to go, but I don't need to go right this minute. Did the person who was the perpetrator of the domestic violence cause a lot of physical damage to the property? I mean, one of the things that sometimes we suspect that what's going on is another type of discrimination, often racial discrimination, and the landlord is using XYZ as an excuse to discriminate on the basis of race. It can also be that sometimes there is no discrimination, but it's still not fair. And I don't know, Abby, what would you do in this scenario where the family is reconciled and the domestic violence is stopped and the landlord's just like, nope?
I think I still need to see the reason for the denial. Is it like because of this specific incident, or is it because they pulled a criminal record and saw that? Cause if it's a conviction, if that's the conviction they're considering under the like criminal history laws, they would need to consider like any mitigating circumstances as well. And that might be the former victim or the victim saying that they reconciled and he has gone through programs like Monique was saying, and maybe submitting a letter or something on his behalf. Again, like Monique said, I don't know that any of these things would necessarily work, but that would be kind of what I would want to try.
And Abby, is this something where like you would have the case manager reach out to you all to help sort this out, or have the client, like the client that they're working with directly can connect with Bela, or either?
Either. Yeah, we're always happy if you have questions and you don't know if it's like appropriate to make the referral or not, you can email to like run fact patterns by us or get some technical assistance. And if it seems like something we'd want to jump in, then I'll let you know and we can figure out that referral.
Great. So I'm going to note we're at time, but I really encourage folks to reach out directly to the folks at Bela if you have these kinds of questions. When in doubt, reach out to them. Do you mind, Abby and Monique, putting in the chat whatever's the best contact information for folks that might have questions like this?
I'll put my email. It's always better to reach me by email.
Okay, great. And I want to
Same
thank you
here.
both for really great training. This was, I liked actually how detailed it got. I think people were really engaged. Abby, I'll get the slide deck from you. I'm gonna have a recording of this and I'll post that and send that out to everybody that attended.
Perfect. Thank you all so much.
Thank you.
Thank you all very much.